Hear ye, hear ye, hear ye. All persons having any business before this honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. Please be seated.
Please call the case.
Case number SCOT 17-777, 811, and 812. In re 30-meter telescope at Mauna Kea.
We are here today, of course, on our second round of appeals following this court's decision in Mauna Kea Nainaiho. I'll refer to it as 1. When we were before this court in 2015. And during that proceeding, of course, much of the argument and the court's subsequent decision was focused on the due process issues. And this court, in a published decision, set out very comprehensive discussion and pronouncements of due process requirements, and including fundamentally in a justice system, justice can perform its high function in the best way only if it satisfies the appearance of justice. For in a popular government, justice must not only be done, but must manifestly be seen to be done. There was a discussion and citations on cases about cold stone neutrality of an impartial judge. There was a discussion and citation about this stringent rule may sometimes bar trial by judges who have no actual bias and who would do their very best to weigh the scales of justice equally between contending parties. And despite the decision of this court and the very comprehensive discussion, this case went back on remand to the Board of Land and Natural Resources, and the board, through a very on remand, there was never a hearing called before the board. So what happened is there were orders issued, despite our objections to ask for a meeting before the board. And the first order that was issued was the appointment of hearing officer Ricky Amano. And that was on or about May 31st of 2016. March 31st of 2016, excuse me. And along with the order that apparently was done through a procurement process, in which one of the board members was also a member of that process, hearing officer Amano also included a very comprehensive of cases that she had been involved with, about people she knew, and where she had gone to college, law school, you know, all these various types of things. And on April 8th, she also submitted a subsequent disclosure. On April 15th, pursuant to the order of March 31st by the BLNR, the parties were to submit any objections. And at that time, it were just my clients, Mauna Kea Nainaiho et al., who were the appellants in Mauna Kea Nainaiho 1. And so we objected to her. After some research, we discovered that through the internet that she was a dues-paying member of the University of Hawaii at Hilo's Imiloa Astronomy Center, a party in this action, the University of Hawaii at Hilo, and of course the Astronomy Center is a subject of the dispute. We objected to her proceeding as such because of the obvious pronouncement of this court. You know, she was a dues-paying member of an actual party in this case. And our objections were overruled subsequently Hearing Officer Amano, in a subsequent disclosure after our objections were lodged, had in essence stated that she had been unaware that the Imiloa Astronomy Center was part of the University of Hawaii at Hilo. And in our motion for reconsideration, we added photos that were online with a big University of Hawaii at Hilo sign right in front of the center. We also raised that the renewal application has University of Hawaii Hilo emblem on it, etc. And despite our further objections and further information that we raised, of course, our objections were overruled again. And the appellees in this case essentially argue that, well, this is just a casual, informal kind of membership. There was one citation about some out-of-jurisdiction case where many years before a judge had been a member of the Sierra Club, I believe. But this is, the crux of the whole thing is we would submit what the whole Mauna Kea 99 Hole 1 was all about. It was about that cold stone impartiality, that appearance of justice. And again, whether you characterize it as a more casual family kind of membership, I think really begs the question, because where do we draw the line as far as due process? If we're going to start making exceptions here for a sort of casual membership, as they want to characterize it, versus any kind of membership.
Mr. Werdeman, I'm sorry to interrupt you, but you're characterizing this as a kind of casual membership, and I wanted to ask you if you could develop a bit the facts that you're referring to. I mean, what, if any, facts would indicate that there's a reasonable impression of partiality, or that a reasonable person would consider likely to affect the impartiality of the judge? What facts?
Well, as far as my characterization, it's actually the appellee's characterization of the casual. I don't think there needs to be any distinction. It's membership with a party. That's before this hearing officer. And we would submit that also, joining an organization, also lends to them supporting their belief, their mission, their philosophies. That's certainly a reason why people join organizations. And this is that whole issue of stone cold neutrality and appearance of justice and appearance of being fair and impartial, I think was compromised by this membership. And
is Imiloa Astronomy Center a separate entity? It's a separate nonprofit, is that right?
Not that I'm aware of. It's part of the University of Hawaii at Hilo. It's on the campus. It's part of the University of Hawaii at Hilo campus. And as I indicated before, there's a big University of Hawaii at Hilo Imiloa Astronomy Center right in front of the building. I would submit that nobody in Hilo would confuse its association with the University of Hawaii.
I'm so sorry. Is it an advocacy organization or an educational organization or both? What does the record show on that? In other words, does it have an express advocacy mission, or might one reasonably expect by joining in that you're simply taking advantage of the educational opportunities? What does the record show?
There's certainly, I think, the educational aspects to it. And there are exhibits that apparently included the TMT project as well. And to the extent that, it includes such exhibits, I guess it could be characterized as advocacy, but nobody from the center actually that I am aware of has actually gone out and appeared in advocacy roles in very tribunals or agency hearings or anything like that.
In terms of administrative adjudicators, this court has, in Sussel, said that they're basically subject to the same impartiality or appearance of impropriety rules as judges. So I'm trying to think this through. Would it be your position that if, for example, a judge, let's say, had a membership in the annual membership in the Polynesian Cultural Center, that judge should recuse from a case in which the BYU Hawaii campus was seeking a permit, a building permit?
Yes, I would agree with that. And
by the same token, then, if a judge who had a membership to Bishop Museum, a judge would be required to recuse from a case, for example, if it involved the Charles Reed Bishop Foundation.
Right. If Bishop Museum was a party to the action, a judge who is a member of the Bishop Museum, I would submit, shouldn't be participating in that.
How far do you think the disclosure requirements would go then? I think I should state then that I have been to the Imiloa Astronomy Center. I accompanied my children many years ago on their 4th grade Big Island trip, so right. I've been in there, and so I'd like to have that disclosed for the record. But do you think that would constitute a grounds for recusal?
I don't think so, and like I said, this is a dues-paying member at the time of the action who failed to disclose that after a very comprehensive disclosure. And I mean, I also cite evident partiality, although it applies, as a court have discussed, to binding arbitrations. But I think because of the deference that the courts give to administrative agencies in findings and conclusions, I mean, it's really a kind of limited appeal as well because of that deference. And unless we start off from ground one with a fair and impartial, cold stone, neutral arbitrator, and they had a procurement list. They could have gone to number 2 or number 3 just as well.
I know you've had a chance to think a bit more about these issues of partiality and conflict of interest. So let me ask you to focus on a couple of facts. Is it relevant to your analysis whether or not the party, in this case TMT, has any financial connection to Imiloa? In other words, whether there have been any contributions made as a result of the TMT project to Imiloa?
I mean, I think that certainly adds to the overall consideration, and that was something TMT also was a contributor, at least the predecessor entity, a contributor to the Imiloa Center.
Do you know the extent of the contribution?
I don't. I just went off of this list that the Imiloa Astronomy Center had produced with gold status, diamond status, platinum status, that kind of thing. So,
well, it appears in the EIS that there's over a dozen references to Imiloa.
Yes.
And much of that is with respect to I think, partly the mitigation that's anticipated that would involve payments. And do you have an idea whether the mitigation would involve payments to Imiloa?
I can't say definitively, but I certainly believe that they at least have a relationship as part of the mitigation to take school groups up to the center to educate them on the process, to work in tandem on those kind of efforts.
Do you know whether Imiloa was among the recipients who received over $100,000 in contributions from outreach activities that were made by the TMT project?
I don't know if it went through that through those contributions, but it appears that they at least made direct contributions to the center. I can't say for sure if it went through the I don't know if it was the Hawaii Community Foundation and then it was subsequently dispersed, but
would the decision of the hearing officer potentially have any effect on the ability of the TMT project to contribute to Imiloa?
I would certainly think so. I mean, if she ruled against them, that conceivably would have ended such contributions. Yeah, I certainly agree that it would have a significant potential impact on that.
But the hearings officer didn't directly benefit from any of those contributions, right?
No, not financially, no. But I don't think that that's determinative of it. She's a dues-paying member, as I indicated, of their mission, of a party in the proceedings. And you know, the easiest thing would have been, and even as I indicated in my reply brief, even University of Hawaii at Hilo and TMT International Observatory acknowledged that. And they had asked that she be removed as well, just because of the issue of appearance of justice. So, you know, it was only the BLNR that I guess at that point decided that you know, they were going to proceed nonetheless and overrule our objections. As far as TMT International Observatory, I mean, they were so adamant about it, is that they were filing things even before they were admitted as a party by the hearing officer, asking that Judge Amano be removed from the case.
We cannot set aside their rulings unless it was clearly erroneous. So which findings or conclusions regarding the hearing officer made by the BLNR are you alleging were clearly erroneous?
I think the whole decision. She should have never presided over the case. And it was again a clear due process violation we would submit even before we got started with the evidentiary hearing. And when we went back on remand again, and it was after these clear pronouncements by this honorable court, we were expecting a cold, stone, neutral, fair, and impartial hearing officer after all of that, or as the court said, either the board or a new hearing officer. The board, I mean, this court made it clear in the first case that it was obviously going to be a new hearing officer, because that first process was the BLNR had put the cart before the horse, and this whole subsequent contested case hearing was really a pro forma process. And if I could just touch real briefly on the Attorney General issue, the two deputies. They obviously were here before this court as adversaries in Mauna Kea 991, and as you know, they argued in their briefs, and this was raised in our motions, the substantive issues. I would submit that the same sort of standard should apply to them on remand, on fair and partiality, the appearance of justice, and they could have simply established a wall within their office and had some other deputies advise the board after.
They actually advised BLNR and DLNR as a neutral adjudicator throughout these proceedings, correct? I realize that is, I think the White case that you cite is distinguishable, because in that case, the deputies had represented the superintendent of the Department of Education as an adversary party and then turned around and represented the Board of Education in a similar proceeding, in a related proceeding, as a new Board of Education as a neutral. So I think the circumstances here are a little different.
Well, I mean, those are certainly the facts in the White case, but I don't think the court limited it to just that kind of situation. And I think the Mauna Kea Nainai whole case, one, certainly clarified any issues about what is to be required by administrative agencies below. And I mean, how can you have a fair and impartial hearing officer if throughout the process leading up to that you have attorney generals who did play an adversarial role, and they certainly played an adversarial role and were part of the same attorney generals who advised the BLNR previously about putting the cart before the horse. So, you know,
but that actually gets into attorney-client privilege issues, correct? We don't know how the BLNR was actually advised by these deputies before, and we never will know. It seems to me that the rule you are advocating here suggests that, for example, any time this court overturns and remands a decision of a judge, that judge and that judge's law clerk who advises that judge would no longer be able to hear the case or be involved in the case.
No, I think in a situation like this one where the attorney generals clearly played an adversarial role against my clients, that they shouldn't be participating in a case like this on remand. Yeah, we don't know to what extent, like you said, was discussed, but we have to assume that since they were there throughout all of the proceedings, throughout months of hearings, that there were some types of discussions. And I think it again is the appearance that this court has talked about, that, you know, how difficult is it to just have some other deputy attorney general advise the board and a hearing officer on remand to address that appearance of justice and impartiality and fairness.
May it please the court, I'm Clyde Wadsworth, appearing on behalf of the state of Hawaii, the Board of Land and Natural Resources, and the related DLNR defendants. A fair and respectful process, an opportunity to be heard at a meaningful time in a meaningful manner, both in reality and appearance. A procedure designed to ensure that the record was fully developed before a decision was made. That was this court's mandate in Mauna Kea Anainaho, and that's what the board provided to all parties in this matter. I plan first to address the due process issues raised by the petitioners, and then to show how the board fully complied with its obligations under Article 12, Section 7 in Kapa'akai. First, petitioners cite no statute, rule, or canon that required Judge Amano's disqualification based on her family membership with Imiloa Astronomy Center, which is both an astronomy museum and a Hawaiian cultural museum. She simply held an $85 annual museum pass, which doesn't carry any more risk of prejudgment than having a Bishop Museum membership, being part of an alumni association, or even just visiting planetarium. And in her disclosures, Judge Amano made clear that she had no involvement in the control, management, or governance of Imiloa. In other words, she had no duty of loyalty. Her alleged relationship to UH was just too remote and tenuous to create an appearance of impropriety. And that's the standard we have here under Sussel, which asks whether the decision maker's impartiality might reasonably be questioned. And here,
but why do you think, if there was no reasonable impression of partiality, as soon as she was informed that the parties knew about it, she said, "Oh, I'm going to cancel my membership"? In other words, why would you need to do that if there wasn't already an impression of partiality out there?
Well, I think, Your Honor, she just wanted to to assure everyone of her impartiality. The issue was raised. She didn't believe that a reasonable person would believe that it would affect her impartiality, but because the issue was raised, she decided to cancel her membership. I don't think it's a concession at all on her part, specifically when she expressly stated in her disclosure that she didn't believe a reasonable person, that it would cast suspicion on her.
What about the fact that the proponents of the project asked for her removal? Is that correct? Isn't that correct? The parties on the other side of the proceeding asked for her to...
Actually, not on the ground that she was disqualified, Your Honor. UH specifically argued that she was not disqualified under the applicable standard. It did... That there was an appearance potentially? Or? No, Your Honor. The argument was that for expediency's sake, because this was taking quite a bit of time, the repeated motions for disqualification, that because of the delay that the board might look to to appointing another hearing officer. There was also, I believe, a concern about it raising potential appellate issue. But the UH specifically stated that it was not because of her not meeting. It was not because she was. Pardon me?
What would be the potential appellate issue?
Apparently the issue that we're here today with, Your Honor. There was just a concern that out of expediency, that the commission, that the board possibly looked to someone else, but it was not because she was disqualified.
Mr. Watts, I'm sorry.
Oh, I was just, the TMT explains it this way. They said, in the interest of fairness to all parties. That's what they said. And that means perhaps one could argue that it would be not fair if she wasn't disqualified.
Well, I think what TMT and UH were interested in was having an expedient end to the process and being able to get on with the evidence, Your Honor.
But it doesn't say in the interest of expediency. I mean, it says in the interest of fairness. I understand that time may have been a factor, but...
Well, it says what it says, Your Honor. Perhaps counsel for TMT can confirm what I've said about it.
Mr. Wadsworth, could I ask you a bit about your conclusion that there would be no reasonable impression of partiality with respect to the relationship, if any, between Imiloa and the TMT project? I think you heard me reference the fact that over a dozen times in the findings of fact and conclusions of law, Imiloa is referred to, and in the environmental impact statement it says that activities have included contributing over $100,000 to the following. This is $100,000 contributed by the project, and it includes Imiloa, and I think, correct me if I'm wrong, the record indicates that at the time that the hearing officer was selected, she was a member of Imiloa. So is that something that would be relevant to consider with respect to whether a reasonable person might find impartiality?
I don't believe so, Your Honor. As Judge Castagnetti pointed out, there's no evidence in the record that Judge Amano received any benefit from any contribution to Imiloa. She had an annual museum pass. That was it. I mean, if that's sufficient, and I can address...
I don't mean to suggest that she would personally benefit, but would it be relevant if her decision would remove from Imiloa an important contributor? In other words, if she decided adversely in this case, could it affect the contributions to the group that she's a member of and that is actually, in this case, getting money from one of the parties?
On the first point, I don't think that the record establishes that it was, quote unquote, an important contributor. I think it's not in the record, but the commitment to Imiloa in the EIS was prospective in nature, and it was about linking science and culture. And equally in the decision and order, the
Now, you're
references.
saying prospectively, and I'm not sure how much difference that makes, but in the reference that I'm referring to, it says, prior to completion of the Chapter 343 EIS process, the project has been involved in a number of outreach activities. So that's since the time of prior to the completion, it says activities have included contributing over $100,000 to the following. So it was my impression that this has already been contributed. Would that affect your analysis, as the money's actually been contributed?
It's a list of organizations that they've contributed to. Imiloa is one of them. Is that right?
Yes.
Okay. So, Your Honor, I don't know the specific amount that they contributed to Imiloa, and I don't believe it's on the record. It's in the record, and so ultimately, I believe it's the burden rests on the party asserting the disqualifying interest to esse that there's a disqualifying interest.
Well, this party, I guess you say, the Mauna Kea party, Mauna Kea Idaho, discovered this information and then brought to the attention of the Board of Land and Natural Resources the fact that there hadn't been a disclosure. So I wanted to ask you about that. In Madamba, that was an issue that was actually considered with respect to evident partiality, the idea that there was not a disclosure. Would that be relevant to your analysis in this case about whether there was a reasonable impression that an individual could have of partiality?
Justice Wilson, I don't believe so. HRS Section 658A-12 sets out the required disclosures for arbitrators, as the Court knows. And the standards for disclosure are arguably higher for arbitrators than for judges, and by extension administrative hearing officers, because judicial review of arbitration awards is much more limited. And here, in fact, Judge Amano made the disclosure as soon as it was brought to her attention. It was before any substantive proceedings in the contested case hearing. So she essentially made the disclosure before the hearing started.
Excuse me. One of your reasons that you actually mentioned when you basically took no position or something was that there was another mediation where you were concerned about that hadn't been disclosed. And so you mentioned that in thinking that there might be another challenge.
I think you're referring to something that UH pointed out in one of its briefs. If we mentioned it, as far as I understand, there was no argument by the parties that she should be disclosed on that basis, Your Honor. I don't believe that's an issue on appeal today. Unless there are further questions on Judge Amano, I'd like to turn to the deputy AGs. Under Clattenhoff, the role of the deputy AGs in this case was to represent and advise the board. They never acted in a decision-making capacity. There's no conflict of interest here because the deputy AGs represented the board at all times and never represented another party. They defended the board's decision and order in the first contested case, and they served as legal advisors to the board throughout the post-remand proceedings and the second contested case hearing. The deputy AG's defense of the first decision and order could not create any danger of prejudgment because they never acted in a decision-making capacity. And ultimately, all public officers are presumed to have discharged their duties faithfully, and there's nothing in the record here that demonstrates that the deputy AGs failed to properly carry out their role. Regarding board members Ewan and Gahn, the board properly denied petitioners' motion to disqualify them. Regarding Mr. Ewan, petitioners have offered no evidence that reasonably cast suspicion on his impartiality. They quote from an interview 20 years ago in which he said, quote, "I don't see what difference it would make to have a few more telescopes up there as long as you cite them properly," unquote, which is just another way of saying as long as they satisfy legal requirements. Mr. Ewan's qualified support of general telescope construction 2 decades ago has no bearing on the proposed construction of the specific TMT project today. Regarding Mr. Gahn, petitioners have offered no evidence to cast suspicion on his impartiality. The only thing they raise is that he voted on the first permit, but in fact this court rejected the same argument in Kila Kila, ruling that the board did not prejudge the second permit for the ATST merely by voting on the first permit prior to a contested case hearing, whereas here the first permit had been voided.
Sorry to interrupt you, but while we're on the subject of the actions of the board members and any possible impropriety or appearance of impropriety, neither of those board members crafted a set of mitigation measures in the conclusions of law and findings of fact that would benefit a organization that they were a member of, correct? And so
as far as I know, the board...
I'm just suggesting that there does seem to be, in terms of the hearing officer, this added point that in the findings of fact and conclusions of law, the organization she was a member of is referred to a dozen times, and the mitigation measures include contributions to that group. So I take it your position is that that wouldn't be something that either the parties or a reasonable person would consider as an indication of partiality.
I don't believe so, Your Honor. I mean, most of what is in the decision order regards the substantial funds that are going to be provided to the Think Fund and to the workforce pipeline under the EIS. And as I said before,
well, I may stand corrected. Your view is that the findings of fact and conclusions of law don't provide for any support to Imiloa?
Don't provide support? I'm not sure which findings of fact you're referring to, Your Honor. I apologize. I don't believe that there's any evidence. I agree that Imiloa is certainly referenced in the findings of facts and decision in order, but I don't believe that there's any evidence that Judge Amano her impartiality was affected by that, and ultimately...
Well, she is the author of the findings of fact and conclusions
but ultimately
of law,
the board had to independently review her decision in order, so she is in a slightly different position even than a judge, because she's not the ultimate decision maker. The board
This is a point. Any sense of or appearance of impropriety perhaps to some extent was affected by the fact that the board later made a decision? Is that your view? That it wasn't her ultimate responsibility?
Yes, Your Honor.
May it please the Court. John P. Manott, appearing for the University of Hawaii at Hilo. I'd like to address first the issue of the university's position regarding Judge Amano, and the specific point that the university has never taken the position that her participation in this process constituted an appearance of impropriety. If you apply the standards from the Code of Judicial Conduct, the appearance of impropriety standard would apply when the judge is an officer, director, general partner, managing member, or trustee of a party. There's no doubt that she was not any one of those types of roles by being simply a member in Imiloa. Now, putting her membership into context, her participation in this association as a dues-paying member essentially amounted to her and her husband's admission and 5 children's admission for approximately $85. If she were to buy an admission each time, the total cost would be approximately $82.50. So all she's doing is getting a $2.50 right to go and access the museum and use the restaurant facilities at Imiloa.
Would it be more relevant, I'm sorry to interrupt you, Mr. Manott, but would it be relevant if actually she had bought many, many memberships? Would that make a difference?
I don't believe so because, number one, it doesn't rise to the level of an appearance of impropriety under the Code of Judicial Conduct.
I understand your argument, I think, to be that as long as she's not a director or somebody that's operating in an administrative capacity, that there wouldn't be any reason for her to disclose.
Correct. And the citations in our brief point out that she would need to be in some kind of a position of power and control for this to have any impact, and she is not in that capacity as a member who simply shows up at the Imiloa on occasion with her family and uses the restaurant or views the facilities.
But I wanted to give you an opportunity to respond to the position that as long as the hearing officer is simply a member of an organization, the relationship between the organization and a party to the case is irrelevant.
I don't think so at all. I mean, it's obviously, as we argued both in our briefs and in our opening comments, that the appearance of justice, the appearance of fairness and impartiality is in jeopardy here. And
why wouldn't the appearance be taken care of by the fact that the hearing officer or the judge isn't in a position of authority or control with the organization that they are a member of and participate with?
Well, I'll use this as an example. You know, if there was a dispute over the amount of lease, say that the Outrigger Canoe Club pays the Elks Club, and the arbitrator or the judge was a member of the Elks Club, not on the board or anything like that, but a member of that, and they had to determine what the fair lease amount would be in the future.
Wouldn't that be a financial interest?
Well, I mean, if the person was just a member of the board?
Of the Elks?
Yes, and they had to make a determination. I mean, there would be no financial interest per se for that judge.
I mean, in terms of what the members have to pay for annual membership for the Elks, I guess. I don't know how it works, but, you know.
It's probably something similar to what they do at the Imiloa. There's this renewal, and the fact that they are a party to a dues-paying member to one of the parties, I mean, I would submit that that's clear appearance.
You're saying that the hearing officer was a dues-paying member of UH Hilo?
Yes.
Dues-paying member of UH Hilo?
Yes.
Because of the membership in the Imiloa Astronomy Center. Is that okay?
And you know, I think the BLNR Council brought up this issue about expediency, and as far as overruling the objections, you know, my clients, we came out with the objections 15 days after the hearing officer was named. And then when she came out with a subsequent disclosure about her membership after the objection was made, you know, we promptly filed a motion of reconsideration with all of these issues. But there shouldn't be a time requirement on due process, especially when it's being done before the hearings have even started, and that's what we did.